Earl. Will the parties please introduce themselves for the record? Mrs. O.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
And ma'am, you are Treyana Earl, is that correct? And you are not represented by counsel today, is that correct? All right. Ms. Izell, if you want to make a record, and then we can inquire into Ms. Earl what she wants to do today.
Thank you, Your Honor. It's my understanding after talking to Ms. Earl briefly today that she was denied by the Public Defender's Office. It's also my understanding that some information may not have been taken down correctly or that there's a potential for an appeal. However, it's my understanding there may have already been an appeal that's been denied. At this point, Your Honor, I would ask that Ms. Earl speak with the court about either finding representation or making another appeal to the PD's office.
All right, thank you. And Ms. Earl, I have you as being denied. The last denial was on July 17th, which was a PCC for this date. And then, and so what is your plan on getting representation?
I just want to get like represented because when I was telling them like where I live, like when I used to pay rent, I didn't say that I still do it, but I guess they put it on there. Like I still have a job, but I don't pay rent anywhere.
All right. So do you plan on going back to the Public Defender's Office?
Because I don't know where it is.
What's that?
I don't know where it is. I'm not from here.
All right. There's two public defenders behind you right now, and I'm sure they can give you the address, or I can give you the address. But right now, you're unrepresented by counsel at preliminary examination. I can find just cause since you're not represented to adjourn this, but then we still have the same problem. If you don't get a lawyer, then we're just going to go forward with a felony. All right. I'm assuming that at some point in time, Ms. Earl wants representation. So if you're denied again by the Public Defender's Office, then you're going to have to get a lawyer on your own. Do you have any names, or have you checked the State Bar of Michigan for any site or names?
No, but I'm sure it's not her. I'll just find it. If I get denied, I'll just look before.
All right. So so what I'm going to do is find just cause to adjourn this because I don't want you waiving any rights without talking to a lawyer. I'm sure you can get the address from somebody behind you. I'd give you an address, but I think I only have the phone number. Okay. Mr. Austin or Ms. Donnelly, can you provide the address?
I will speak with Ms. Earl.
My understanding is that you spoke with them before, they've denied you. But if you believe there's a mistake in the application, we should get that all figured out. Here's the problem. The problem is I'm going to set this again for preliminary examination. And if you're not represented by the Public Defender's Office, you're going to have to hurry as fast as you can to prioritize this to get representation because the felony's not going away. Okay. All right. So I'll find just cause to adjourn. I have a denial from the PD as of July 17th. And then what's the one before that? No, but what's the first denial?
Oh, I'm sorry. It was on July 17th.
So that's been the only denial.
And then July 21st.
July 21st. I'm going to make note that the two denials have come from the Public Defender's Office, July 17th and July 21st. That was 3 days ago, but the information may have not been provided correctly. So you can get that from you can get PD to make application once again, but we're going to do 30 days out. But at that time, if you're not represented by counsel, we got to figure this out because
does it normally be like 2 denials? Because I only went to court 1 time.
No, this is unusual. Okay, so you usually at this time, what we're doing is you got to get a lawyer. We're going forward, okay. Right? That's usually the case. Okay,
Your Honor, I don't want to interrupt, but if it would help, can I help with the record here?
Sure.
I have the notes, and obviously, as from a member of the Public Defender's Office, I might have some information to shed light on this.
Absolutely. So, Ms. Donnelly, you can indicate your appearance to the record. More so not on his representation,
no, but
just to give us information.
Yes, Assistant Public Defender Sarah Donnelly. My information in the file is that Ms. Earl was denied because she's not indigent. She makes too much money. It has nothing to do, in fact, obligations reduce the amount you earn and actually help you qualify. If she doesn't have rent, then per my information, she makes too much money at her job. It's if the information that she reported about her income is incorrect, we can correct the application and resend it off. But the appeals process is actually different. So if the information's not different, like if her income's is actually not lower, then the appeals process is that she actually has to go to 3 attorneys and get basically consultations and basically, offers for retainers.
Right.
And then if she can't afford that, she can come back to the office with that information and try to appeal it. That's the only way to appeal a denial. If she was denied, and if the information is correct, then she just submits a new application.
So right now, we just want to work on the new application.
If the
We don't want to put her
information, if
through
her
the,
income information is incorrect, I can correct it and submit a new application.
Perfect.
But if her income information is correct, then she's denied based on that.
right, and then the only avenue is the appeals process.
There's an appeals process, getting
Right.
those, yeah.
And you've indicated on the record that if you think this is a situation where they didn't have the correct information.
Yeah, like, could I bring like check stubs in or
Ms.
something?
Donnelly might be able to correct that
Like my
information.
pay stubs?
You don't need pay stubs to prove it. We're simply on your word. Your word was that you made over our income asset limits. Now, if that's incorrect, then I can correct them without any need for pay stubs.
Okay.
All right, so let's try it that way first, okay? Let's try it that way. If we are in the appeals process after that, there's nothing we can do about that. But I think that's more succinct to getting you an attorney. If you're denied a second process, you're gonna have to prioritize this to get a lawyer, okay? Let's adjourn this, I would say 30 days. I would think that's fair, 30 days, especially if you have to get a lawyer, then they're gonna have to review the discovery, they're gonna have to file an appearance. Multiple things are going to happen. Mrs. L, I think 30 days is a fair assessment for the adjournment.
I think that'd be fair.
All right, so we'll use just cause to adjourn 30 days for,
I have 3 weeks or 5 weeks, so
let's try 3 weeks.
let's do 3 weeks. So August 14th at 9.
August 14th at 9 o'clock. So the prelim is scheduled for August 14th at 9 o'clock. Ms. Donnelly might be able to correct the information going forward. If there's a continual denial, then show up represented on August 14th at 9 o'clock. Right, ma'am? Right, ma'am? Okay. Anything else for the record in 25-01-921, Mrs. L?
Not for the people.
Mr. Earl, do you have any questions of me?
Yes, I believe I have like another court date August, with the date that you said, but I'm not sure. I have to check.
All right.
Like,
Right now, you're due here on August 14th at 9 o'clock for prelims. If that's a conflict, then we can check to see if you have another court date.
yeah,
But right now, it's August 14th at 9 o'clock until we see differently, all right?
yeah, I can call and,
All right.
like email the paper or have them fax or something.
You'll get notice from my court officer right now, all right? Thank you. All right, Mrs. Zell, where are we heading next?
Your Honor, if we could. Good, but if you're stepping out for a moment, I can do something else.
All right.
Close it off a little bit. If we could have Mr. Johnson brought up, Tyrion Johnson, for the remainder of his exam, we can finish that.
All right, so let's bring up Mr. Johnson. That's Mr. Austin's. And then Miss Donnelly was on Davidson case.
Correct, Your Honor.
We've had 2 witnesses testify already. Is that correct?
That is correct, Your Honor.
Fox and True.
That is also correct.
Mr. Johnson, how are you?
I'm well, Your Honor. How was the court today?
Pretty good.
The problem is the subpoena system. And we just found out yesterday. Some of them initials for it.
So I don't know if, I don't know what you're doing. I don't know what's going on Davidson. Is that going to be a hearing or is that going to be?
I'm going to be asking for an adjournment on that one, Your Honor. The necessary officers on that case are not available today. One of them was injured yesterday. And then the remainders did not receive their subpoenas. We had an issue with some subpoenas. in our
All right.
office.
And is Davidson I have him as incarcerated.
Correct, Your Honor. He is right here.
All right. Let's go and put that on the record. Since we know. And we can do that in the meantime of bringing up Mr. Johnson.
All right. Thank you.
All right, so we're on so make sure you're good, then I'll get Mr. Johnson.
Yeah, that makes sense.
So this is Mr. Davidson. All right, so we're on the record in docket 24-02478.
Yeah, it's just, yeah, right here.
And that is people of the state of Michigan versus Monty Davidson. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Ms. Tom.
Assistant Public Defender Sarah Donnelly on behalf of the defendant who is standing to my right.
And sir, you are Monty Davidson, is that correct?
Absolutely.
Thank you. This is the time set for a preliminary examination today. Mrs. L, how we proceed?
Your Honor, at this time, the people's necessary witnesses, who are mainly officers in this case, are not here today. The officers that are not here One was injured yesterday and has been told by medical professionals to stay off her feet, to stay at home. So she was unable to come today. The other officers, Your Honor, I'm not sure exactly why they're not here today. However, I have been told by multiple officers who have appeared today that we are having an issue with our online subpoena system for those officers. They are having a hard time viewing their subpoenas, seeing if those subpoenas are being called off or staying on. However, Your Honor, I would like to just make it very clear, there is a lay witness in this case, the complaining witness, who did not appear today. We have no reason to believe their subpoena was not sent to them. We have not had successful contact with that witness specifically. Your Honor, today we do ask for an adjournment in this case to get the officers here to support the charges that they can testify to.
My understanding is the defendant waived the 21-day rule as of September 26th. So we adjourned for once for good cause in September. And then we left on in October 18th. And then the defendant was failed to appear on November 14th. Was rearranged on July 8th. And then we set this, Ms. Thompson.
Thank you, Your Honor. Yes, we would not be stipulating to that adjournment. Obviously, this was the date and time for set for a preliminary exam. It seems like the prosecutor has issues with a lot of they have issues with a lot of the witnesses, not just officer witnesses, but if they have a lay witness they can't get in contact with, Your Honor, then we'd be asking for this case to be dismissed. Mr. Davison is now serving another year in prison. As long as we keep continuing this, you'll have to keep reading him over. So we ask the court to dismiss. Thank you.
All right, thank you. It appears Mr. Davidson has another year, which will be placed collectively with this one. I have bond at 5,010%. Is that what is that the current bond right now? So time is collecting on this file.
It's not, because he's serving a sentence.
Oh.
So no, he's not getting any credit.
Mrs. L, is that your understanding?
That is my understanding.
All right. I have a waiver of the 21-day rule and a fail to appear bench warrant. So he was rearranged as of July 24th. I don't know, the fail to appear was while he was incarcerated. That may be the case. I'm going to grant one adjournment. In this matter. It looks like we've been here before, but it hasn't been set. Well, we've set it for prelim in on November 14th. That was the fail to appear, and then they're rearranged in July. So I will grant one adjournment for the prosecution for lack of witnesses, and 3 weeks should be sufficient time for the writ, I would think.
August 14th at 9:30.
Okay, August 14th at 9:30. And then, Mrs. L, if we have the same problems, then you understand this court is kind of this court will visit that issue on the 14th. All right.
I understand. Thank you, Your Honor.
All right. Anything else for the record? So I find a good cause to adjourn for this matter. Previously, the 21-day rule was waived on this file, and then there was a fail to appear. So we'll be back here on August 14th at 9:30, and the court will take care of the writ. Anything else for the record in 2402-478? Mrs. L.
Not for the people.
Ms. Donovan.
Not for defense.
All right, you're all set, Mr. Davidson. We'll see you on August 14th.
Jan might be having some issues.
Mr. Johnson,
I think in general.
or in general?
Don't say that. I gotta go down there and talk to you. Maybe.
So Mr. Etheridge was here for a second. Thanks for your help on Miss Earl, Miss Thompson.
I think you're, I didn't want to impose, but I wanted to make sure that the court knew exactly what was going on.
Right,
with
right.
our office.
And there's a difference between the appeal process and the information process.
Exactly, yeah, she was reporting like $1,700 in income, and that's way over our limit.
Right.
Now
right.
she's reporting it way less.
Okay.
We'll see what happens.
All right, that's perfect.
Okay.
That's just the one I got.
Let me as you may have heard, I'm having issues with our subpoena system, so.
Sure.
Yeah, no, I appreciate the heads up.
All right, so we're on the record in docket 25-01766. That is people of the state of Michigan versus Tyree and Johnson. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Lizal, Assistant Prosecutor for the people.
Mr. Austin.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Johnson. He is present with me at council table.
And sir, you are, correct my pronunciation, Tyree and Johnson?
Yes, sir.
All right, thank you. This is time set for a preliminary examination continuation or preliminary examination. Is there anything to come to the court's attention besides the obvious sequestration invocation, which I'll leave kind of to counsel, that if there's anybody who shouldn't be watching another witness testify, we'll continue the sequestration process. Mrs. L, is there anything else to come to the court's attention?
No, Your Honor, not from the people.
Mr. Austin.
I have no preliminary matters, Your Honor.
All right, then the people may call their next witness.
Thank you, Your Honor. At this time, the people call Officer Jake Ellis to the stand.
And then the fan, I'll leave up.
Sorry. No, I'm typing, I know what you're talking about.
I might eventually. All right, Officer Ellis, you can come forward. Please state and spell your first name and your last name for the record.
It's Jake Ellis, Jakeellis.
All right, please raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of
I
perjury?
do, Your Honor.
All right, please have a seat. As you know, the microphone is just for recording purposes, so please project as best you're able, as best you can. And Mrs. L, when you're ready.
Thank you, Your Honor. Thank you for being here today, Officer Ellis. If I could just start by asking, where are you currently employed?
The Lansing Police Department.
And how long have you been employed there?
6 years and 2 months.
And what's your current position?
Patrol officer.
And do you recall working on June 14th, 2025?
I do.
Do you recall what shift you were working?
Night shift.
And on that day, do you recall responding to a traffic stop?
I believe it was a call for service.
Okay, can you tell me more about that? What was the call for?
We were asked by the Michigan State Police to attempt to locate a subject on domestic violence charges that they had.
Okay, and what was the description you were given?
We're looking for Karen Johnson. I was familiar with him from prior calls service at 526 South Chestnut.
And was Mr. Johnson found that day?
He was by their officers, yes.
And did you interact with Mr. Johnson on that day?
I did.
Would you recognize him again if you saw him?
Yes.
And do you see him in the courtroom today?
Yes.
Could you please describe him by something he's wearing?
He's wearing the Huguenot jumpsuit the defendant did.
Thank you. Your Honor, at this time, we ask that the identification of Mr. Johnson be entered.
Any objection to the witnesses identifying the defendant for purposes of prelim, Mr. Austin?
Without objection.
Without objection, the witnesses identified the defendant for purposes of prelim. You may proceed.
Thank you, Your Honor. And on that day, what was your interaction with Mr. Johnson?
After he had been arrested and pursued by their officers, I transported him to the hospital for medical clearance.
And which hospital?
Sparrow Hospital.
And is that in the city of Lansing,
Yes.
in the state of Michigan,
Yes.
in Ingham County?
Yes.
Thank you. And when you were at Sparrow Hospital, can you tell me what happened there?
Yeah, we were placed into one of the triage rooms, waiting to eventually make it to one of the other rooms in the emergency department. For several minutes, he continued to make numerous threats to assault me, wanted me to take his handcuffs off, take my badge off, and eventually he stood up and squared up to me and with his hands on his back was trying to take some sort of like assault posture towards me.
And when he took that assaultive posture, how did you respond?
Told him to sit down. He repeated numerous times to take my badge off. Obviously, I didn't do that, so I went over to him. I placed both my hands on his shoulders and tried to gently guide him down in the chair. At that point, I felt him tense up and start pushing against me. So that way, I couldn't put him back in the chair, so I had to use a little more force, and I had to physically set him back down in the chair he had been in.
And did he remain in the chair after that?
He did, but he tried to get up numerous times. Eventually, I had to call for some officers to bring some leg irons so I could better control him. I could continue to feel him pushing against me, trying to get out of the chair. So eventually, I put him onto the ground to get a better position of control.
Thank you. And during all of this, can I ask what were you wearing?
I was wearing a fully marked Lansing Police Department patrol uniform.
And Mr. Johnson was under arrest at this time?
Yes.
No further questions, Your Honor.
Cross-examination, Mr. Austin.
Sure, thank you. Morning, officer.
Good morning.
So backtracking here, you said that you had been contacted by Michigan, the Michigan State Police regarding a domestic matter for Mr. Johnson. Is that right?
Our dispatch had yes, and
Okay.
okay. Call for service.
And they, of course, relayed that information to you.
Yes.
And your understanding that was a matter out of Eaton County?
I didn't know exactly, or I can't remember exactly if they told us it was Eaton County, but I knew it wasn't in the city of Lansing at least.
That it was or was
It
not?
was not within the city of Lansing.
Okay. And as you understood it, what were you supposed to do if you encountered Mr. Johnson? Detain him or arrest him or something else?
Using me placed under arrest for Michigan State Police, their charges.
Okay. And is that something that was directed to you in the dispatch, or is that just something that you had assumed?
No, they've requested that we locate him, and if he was located, placed under arrest, and they would pick him up from us.
And were you aware, or did you check to see if Mr. Johnson had a warrant out for a domestic in Eaton County prior to responding?
I ran him and lean. I did not see a warrant for that instance now.
Okay. And when you initially came into contact or saw Mr. Johnson, was there already some interaction between him and some other officers already taking place?
Yes, he had been caught in a foot chase, tased, and placed in handcuffs.
And so whatever happened from the beginning of that, you would not have seen it because you weren't there from that interaction from the beginning. Is that fair to
Correct. When I
say?
first interacted with him, he was already in handcuffs.
And did I understand correctly that you stated that Mr. Johnson was later taken to the hospital?
Yes.
Okay. And was that because he'd been tased?
Yes.
And Mr. Johnson have any injuries that you can see?
At that point in time, I could see like some small abrasions just from hitting on the cement.
Okay. And where were these abrasions?
I don't exactly recall. I think elbows, knees.
Recall anything on the face, arms, anywhere else?
Not that I can recall.
Call any bruising?
Not that I can recall.
Thank you, officer. I have no further questions.
Redirect Mrs. L.
No, Your Honor, thank you.
Okay, this witness be excused from the people,
You may.
from the defense.
Yes.
Sir, thank you for your appearance today. You're excused. Any further witnesses today, Mrs. L?
No, Your Honor, at this time, the people rest.
Any proofs today, Mr. Austin?
We'll rely on the evidence presented, Your Honor.
All right, thank you. Motion for bind over, Mrs. L.
Thank you, Your Honor. Your Honor, at this time, Mr. Johnson appears in front of you on 3 charges. The first of charge being a resisting and obstructing police officers causing injury, and the other 2 just regular resisting and obstructing police officers. You heard from 3 officers in this case, Officer Mark Fox, Officer William Turbo, and Officer Jake Ellis. All 3 of these officers described to you that they were responding to a call of service specifically for the arrest of Mr. Johnson, all of whom they were familiar with from previous interactions and from the description provided from Michigan State Police. The officers did end up seeing Mr. Johnson, did tell him to stop, did see him turn away from them and continued to walk away and then ran away. Officers Turbo and Officers Fox gave multiple commands, chasing after him, giving multiple warnings for him to stop. All of these were ignored by Mr. Johnson. During this chase of Mr. Johnson for his compliance, Officer Fox sustained an injury to his knee when he twisted it and it fell. Additionally, Your Honor, once this happened, Officer Turbo was then forced to use a taser to gain compliance from Mr. Johnson to get Mr. Johnson in custody for this arrest that they had valid reason for. Once Mr. Johnson was in custody, the resisting and obstructing of officers did not stop. He was taken to Sparrow for his own health and safety, to be checked on for his own health and safety, when he decided to square up to Officer Ellis. Additionally, Officer Ellis stated that Mr. Johnson told him to take his badge off, made threatening statements of assaults, and eventually Officer Ellis had to get assistance to get leg shackles to get Mr. Johnson to comply with basic commands while he was already detained and in custody for this arrest. Your Honor, at this time, we believe that we've met a probable cause standard through these 3 officers to show that Mr. Johnson did resist and obstruct Officer William Turbo, Officer Jake Ellis, and did resist and obstruct Officer Mark Fox to the point of injury in this case. We ask that all 3 counts be bound over. Thank you, Your Honor.
Thank you. Response, Mr. Austin.
Yes, thank you, Your Honor. I'm going to be opposing the bind over on all the counts. I think before we get to the factual matters of whether or not Mr. Johnson was being compliant, whether or not he was resisting or not complying with any commands of the officers, I think we have to go back to the initial contact they were having with him in the first place. Now, the people have asserted in their motion for bind over that they had reason to have contact with Mr. Johnson, that they were there to arrest him. What the testimony was, Your Honor, is that there is a dispatch for these officers apparently to arrest Mr. Johnson at the request of the Michigan State Police for an alleged crime that did not occur within the city of Lansing or within their jurisdiction. All the officers that I questioned when asked if they were executing a warrant or if they were arresting Mr. Johnson on a warrant, or if they were aware of any type of an existing warrant that they were there to arrest him for, they all testified in the negative. They were unaware of any type of arrest warrant, and they were not there to execute any type of warrant for some type of new charge. So assuming the testimony is true, that the Michigan State Police had contacted the Lansing Police Department directing the Lansing Police Department to arrest Mr. Johnson for a supposed domestic situation in Eaton County, which apparently had not been issued because there was no charge or no warrant for it. My argument is that that is invalid. And I think the case law is clear. If they are there to arrest Mr. Johnson, then, and I'm quoting directly, the arrest, whether an arrest was constitutionally valid depends in turn upon whether at the moment the arrest was made, the officers had probable cause to make it. That is, whether at that moment, the facts and circumstances within their knowledge, and I think that is a key point here, within their knowledge and of which they had reasonably trustworthy information was sufficient to warrant a prudent man in believing that the defendant had committed or was committing an offense. The case that I'm citing is People versus Jones. That is 12 Mishap 369 at 377. That is a 1968 case. So at best, the officers were relying on another agency just saying, hey, there's Mr. Johnson, go out and arrest him. They have no information about this case, what the facts are. They have admitted that there was no valid warrant that they were executing on at the time. Simply because another law enforcement agency on an alleged case from another jurisdiction, I don't believe gives Lansing Police Department the right to approach Mr. Johnson and arrest him. Just based upon that, they had not witnessed him commit any crime. There was no warrant for his arrest at that time. At best, they were told by the Michigan State Police, hey, go arrest him for something that happened in some other county. So I believe that is constitutionally invalid. And if there was any resisting or non-compliance on the part of Mr. Johnson, he had a right to do so because it was unlawful arrest. I would ask the court to deny the people's motion for binding.
Thank you. Response, Mrs. Upton.
Thank you, Your Honor. I'll try to be brief. Just in response to defense's argument here, it's hard to say that the officers didn't have reason to believe that a crime was committed by Mr. Johnson when they were told by Michigan State Police that a crime had been committed and that it was by Mr. Johnson. And that was the impact that those words had on those officers. Even if there wasn't enough at that moment for a probable cause arrest, though the officers seemed to believe there was and testified that they thought there was, they did have reason for a detainment or even just a brief investigatory stop. This is a valid reason for these officers to make that stop and still request Mr. Johnson to stop, yet he didn't. He ran. At that point, there's resisting obstructing, there's additional grounds for arrest, and we ask that this case be bound over. Thank you.
And Your Honor, may I just
You
briefly
may.
respond to the new issue now of an investigatory stop? So I don't think that's going to justify this either, because the purpose of an investigatory stop would be either to support or to dispel some notion that Mr. Johnson had committed or was about to commit a crime. But the officers admitted at this point they know absolutely nothing about this particular offense. They don't know when it occurred, who it supposedly occurred to, who the alleged victim was. So how could they possibly do an investigatory stop and investigate that matter and either confirm those suspensions or dispel them? So again, my argument is the same.
Thank you. I find, based on the testimony of Officer Mark Fox, Officer William Turvo, and Officer Jake Ellis, and I had the opportunity to go back through the notes, through my notes, based on their testimony, Officer Fox indicated that although they were told to assist, that he was first trying to make ID, trying to make it so he indicated that there was a shirtless male observed, and he was stopped for investigatory purpose. And as he approached the shirtless male, seeking to make identification on Mr. Johnson ran, and that started the whole process. So even before identification could be made all on Mr. Johnson, through the testimony of Mark Fox, Officer William Turvo, and it appears Officer Jake Ellis, who talked about the transportation issue to the city of Lansing, it would appear that first investigation was just to make some type of, you are the shirtless male, you are associated with this. They may have indicated that they know Mr. Johnson, but they want to confirm the identification. And they didn't even get to confirm the identification because Mr. Johnson at that time appeared that he ran. And that's when all this started. That's when, so I would say at least the initial investigative identification is it becomes a problematic as Mr. Johnson doesn't even allow that, according to the testimony. So the standard for preliminary examination is probable cause. I find based on the testimony of Mark Fox, William Turvo, and Officer Jake Ellis, that the people have met their burden at a probable cause level. The location changes because obviously the hospital is different than the original running from the police officers. But this all occurred on June 14, 2025. I find that count one is the different count. That is the officer Mark Fox indicated that he hurt his knee. He's about 80% now. He hasn't been able to walk on the knee. He sustained injury, and therefore I find probable cause that location, offense, venue, ID, and date has met. He indicated that Mr. Johnson was the person who was identified as the individual. And so I find that Mr. Johnson did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Mark Fox and caused a bodily injury requiring medical attention or medical care to Officer Mark Fox by running and being chased. And therefore, count one has been proven at a probable cause level. Counts 2 and 3, which are the 2-year RNO, one occurred at 526 South Chestnut. That is with Officer William Turvo, and the similar resisting and obstructing the order by running and then being tased by Officer Turvo. And everybody was marked in a full police uniform. And the defendant knew he was running from law enforcement and he's being chased by law enforcement. And then at the hospital, it appears that the defendant on June 14th, and this has 600 West St. Joseph Street in the city of Lansing. I would think is that the address for Sparrow Hospital?
I believe it is.
All right. Did assault, batter, wound, resist, obstruct. Officer Jake Ellis indicating that he was threatening people around him. That the defendant was also contrary to understanding the instructions. He had been tased. He was being there for treatment, and then Officer Ellis had to call for leg irons because his testimony today was that the defendant would not sit down. Kept on getting up, kept on confronting him after he was told to sit down. That's resisting, obstructing. I find there's probable cause evidence to bind over on the 3 counts. So I will bind over as charged on all 3 counts. And I will. So, Mr. Johnson, your time in district court is done. You're off to circuit court where you'll get your next appearance date from your attorney, all right? All right. So it was held on today's date, finished on today's date, which is July 24th. This is a continuation from the July 3rd preliminary examination. And I find a probable cause to bind over on the charged complaint. Anything else for the record in 25-01766, Mrs. L?
Not for the people.
Mr. Austin?
No, Your Honor, thank you.
All right. I will sign the bind over documentation. And you'll get your next date in circuit court from Mr. Austin, your attorney. Thank you for your appearance today.
Thanks, Tim.
Do we need anyone else for that? I don't think so, but that's, I never know who's in custody. So. Not ready.
I would, Mr. Austin, do you want the transcript?
Yes, please.
You step over here, please. Mrs. Al, did you want the transcript?
Yeah.
Here's that row. I just marked up on the 15 trees. That's where it was turned sideways. I was for today, but this morning. Yeah.
Yes.
Do you want Megan to bring up Mr. Kissy for the waiver while we have Mr. Austin?
We can if he's ready for that. I don't mind.
She's radio with her.
Guess that's fine.
That was set for this afternoon. That's, so Mr. Austin, you're on that case.
Yes,
And then you're covering for, is that Ms. Delvero's case?
it's actually Miss Lawton's, but she's.
Ms. Lawton, okay,
Correct.
all right.
Mr. Austin, would you be available to do that now?
Yeah, I can be.
Okay. I know you said you had some other things.
I have 10 o'clock prelims with Judge Simmons, but I think we should be able to do it.
Okay, let me see if I can catch you on the radio.
Well, let's take a break and then just let us know. Are you ready? Do you need to talk to anybody or?
Yeah, I need a few minutes.
Yeah,
This whole subpoena issue with officers is throwing me off a little bit.
I bet. All right, just let us know when you're ready, all right?
Thank you.
All right. And I think Ms. Laviak's bringing up Mr. Kissy.
Thank you. How's the morning back going? It's going good. That's about it. Oh, your dress is cute. It's very good for me to eat, right? I don't have any date right now. Do you want me to bring this to you? I'll give you a call, like, no, it's just gonna be- So we won't be dragged in until then, but let me get you the date for tonight.
Something wasn't right. I have no idea what happened. Came in my house.
Did you know that you're like, sure you know this and that happened, you just gotta make sure we have it. Okay, thank you. Oh. No, she's. Oh, no, she, everything's not gonna be sure that she's gonna die, dude.
This guy here doesn't try.
So, that's what I need. Can you go see if they're having this issue in insurance? Yeah. Or the subpoenas in. Yeah. Excuse me, so I'm just gonna squeeze behind you. Thank you. having this issue because then I'm gonna look like I'm the problem. Yeah, I don't wanna be the problem.
Hey, how you doing? You wanna help me find this double marker again? I had a hard enough time finding it the first time. It's just by happenstance. Get up here again, I guess. So over an hour
Last
late.
time he showed up late, so he'll show up late again.
Well, he's over an hour late. How late was he last time? Like an
It
hour?
was about an hour last time.
All right. Well, I'm going back to Simmons, maybe. go to those.
Simmons courtroom was packed.
Huh?
Simmons courtroom was packed. I just talked to them.
I'll be down here so I can see you.
Yeah, mail. I'm in.
New mail,
Mail.
new mail,
New
because
mail.
we got that previous anonymous letter.
I know.
Look at me, I didn't send it.
No, it just cracks me up with some stuff. People have got to quit watching CSI or whatever they're watching. It's not how court actually works. Judges don't get to read expert anything. Even if you address it to the judge, the chances are the J is still stuck open in
I
time.
get along with pretty good. Just like Jay today.
She said, no, we don't watch it. She just made you run an errand.
What do you want to take it over?
You get along with Wendy on our review here tomorrow. Is that actually gonna go? They're gonna get coverage. I don't think- Competency, Lauren Morris.
I have not gotten anything new. The judge prefers to put it all on the record, so if somebody can fill in or if you want to copy it.
Freeman's gonna fill in.
Okay.
Did we ever get an order? I think he's gotta be here for a sentence in person.
We got the original report, but we haven't gotten anything since.
By part, and then they just go, I don't know what case I'm here for, you tell me.
Date that we
How
had
do you
the
not know?
hearing.
It says it on your, you know.
Oh,
Oh,
trust
trust
me,
me,
I
I'm
will look
not
at
happy with that either.
I think we turned in a proposed order.
I thought we sent the order to forensic. How else would they know
Another
that
one?
you-
He says.
No, 'cause
Apparently.
We had the hearing, he was
Right.
found incompetent, but I don't think an order.
Love
was-
that. That's
Yeah.
interesting.
I do them as soon as
At
I
least
get
it's
the
only
report.
one page this time. It was two, front and back last time.
Because
I don't know
remember,
what they put.
They never said
remember
their
what I was
They
pointing
never
at Jared, remember
And-
Jared
no, it's his
covered for
mom.
it, there was a big
Oh.
confusion about us
It's
not
his
even
mom,
having a
yeah.
hearing.
She
and
says
then
it in
we
the
had to
first
look it
one,
up, and
it's
then
the
you
same
found it on
handwriting.
YouTube, JIS.
That was
Yeah.
just, he is his mom.
Yeah, I'll find it for you and I'll get it to you. If
No.
you give me a few minutes, I
Okay,
might
so
actually be able to do. the
Maybe
software.
mom had caregiver write a letter too.
Okay,
The
I'll come
first
back
one
and
was
look for it.
mom.
I got like 5 or 6 cases over
It
there.
I
literally
didn't
says
see
this
that.
is
Yeah,
Joey
so-
Kissy's mother.
Started.
Interesting. You want that back?
Here, this is your
Oh,
copy.
But
perfect.
Freeman
I
will be
wanted
covering
one.
tomorrow.
Okay, thank you.
Sure.
Let me try to find that. You want me to send it with Mr. Austin if I find it?
Yeah, or I'll come back.
What?
She can give you the.
I didn't get to read this.
Oh,
one.
yeah.
doing?
Give you the competency.
Well, this is different.
Oh, Lauren Morris. Okay.
Can't really read
Come
it.
back in. Give you numbers.
They come looking for me.
Okay,
No, it's not.
we got like 5 or 6 cases still over there. And then Dylan. Martin's stuff.
Oh, I know who it is now. I can. Let's try it. Okay, officer.
Well, are we ready on the kissing one? Is that all we have ready right now?
Yeah, pretty much. I'm gonna try to step out for a second if I can.
Okay.
Megan, do you have a sticky note I could steal?
Big one or a little one?
A little one's fine.
It's gonna cost you.
One hard case dodged, I guess.
Yeah. Yeah, that wasn't real. And so they ordered the transcripts for you. Like, oh my goodness. Nobody paid attention. You just has, just read it. Just question, answer, question, answer, question, and just read it. But I, Dragon Chuck, she just played.
Yeah, such a general, everybody, you know. Can you hear the testimony of this witness? That issue. Yeah. Okay. Okay. I have no idea. That's incredible. I think he had a good case though. See. He did the principal. Did he?
They seem to.
She said. Central. She- Timothy. I don't recall. By the names. It doesn't register. Tell me two things in case I'll flip you. Yeah. Timothy. The names.
All right, Megan, we're ready on stuff. We can roll.
You did not
Whatever.
RSVP.
That means I can leave, right? That means I can just up and go, right? If I didn't RSVP this party.
Oh,
I'd love to.
We're ready on stuff. Where is everybody?
I have some stuff I think.
We
can do
have
right.
this stuff. I got a prelim with Ward and I got here. and- Did you ever find out from Howard, for Howard? Did you get?
Yeah,
your-
yes.
Did I hear?
Sorry. I was just emailing you actually and then got distracted. I have an officer here. The other officer is unavailable. I can run it victimless. I would just have to start it today, continue it to another day, which just seems like a hot mess. But that's where I'm at with it. So I'm not
Yeah.
willing to let it get dismissed today.
All right, but you're willing, if we waive today, to dump, or not dump, but you're willing to. Yep.
All right.
I can, waiver.
Here we see them.
It needs on that.
Turn up the fan back on.
Are you ready?
Mrs. L, what case are we calling?
Yeah, I'm ready on phone.
Okay, well, if we can call the Hunt case, that would be preferred, but if otherwise, we could either bring up Howell or Kissy to continue moving forward.
Well, Mr. Austin's here on Kissy, right? All right, let's bring up Kissy.
Yeah, Mr. Hunt was in the hallway. I thought he was following you, but he must take his seat back down then. Okay, but he is here. Stop.
Great, and I have both officers here ready to run that exam, so.
All right, so did you want us? I'll leave it up to you.
I'm ready to start if you are.
Yep, let me go grab my client. If that's what you're gonna do, let's do it.
I don't know this. Officer Washington first.
And then we may take a break just to do the Kissy. Is Kissy a waiver or is it a?
It is a waiver, that
Okay.
is my understanding. It's also my understanding there may be a motion made for bond as well. So
All right. So let's start the Hunt case because because we honestly don't know how long it's gonna take to bring Kissy up. And then we'll take a break during those proofs and put Kissy on. All right, so let's go on the record. So Ms. Schroeder and Mr. Hunt. So we're on the record in docket 25-02-009. That is people of the state of Michigan versus Calvin Hunt. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Ms. Schroeder.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Hunt, who is present. Who's stand up, sir? And stands to my right.
And sir, you are Calvin Lamar Hunt, is that correct? Right, thank you. This is time set for preliminary examination today. Mrs. Zell, how are we proceeding?
Your Honor, it's my understanding that the defense would like to exercise their right to have a preliminary exam today. The people have 2 officers that are here and ready to testify to move forward.
All right, is that a fair statement, Ms. Schroeder?
It is, Your Honor.
All right. We will invoke a motion for sequestration
Yes, thank you.
so that everybody, so that one witness does not get to see another witness testify. I think it's only a public defender and prosecutor personnel. We have one witness ready to go. But I don't see, but I'll leave it to counsel to let me know if we need to sequester any witnesses. Are there any other matters to come to the court's attention, Mrs. L?
Not for the people.
Ms. Schroeder.
Now for the defense, thank you.
All right. The people may call their first witness.
Thank you, Your Honor. The people call Officer Christopher Mosby to the stand.
All right, Officer Mosby, you can come up here. I'm gonna have you stand in front of me and state and spell your first and last name.
My name is Christopher Mosby, Christopher CHRISTOPHER, Mosby MOSBY.
Thank you. Please raise your right hand. Do you solemnly swear affirm tell the truth, the whole truth, and nothing but the truth, and a public perjury?
I do.
Right, go and have a seat. I'm gonna have Mrs. Zell, if you would turn off the fan.
Absolutely.
All right. The microphone is for recording purposes, doesn't amplify your voice, as you know. So please project to the back of the room, and Mrs. Zell when you're ready.
Thank you, Your Honor. Thank you for being here today, Officer Mosby. If I could start by just asking, where are you currently employed?
The Lansing Police Department,
And how long have you been employed there?
about 3.5 years.
Do you remember working on July 4th of this year?
Yes, ma'am.
And do you recall what shift you were working?
I was really on a special assignment for the July 4th festivities, so no particular shift.
Okay. Do you recall making a traffic stop that day?
Yes.
Do you recall what car you made a traffic stop on?
It was well, there were several cars that day, one of them being a red Cadillac.
And where did you see this red Cadillac?
At Oakland and Center initially.
And is that in the city of Lansing,
Yes,
in Ingham County,
yes,
in the state of Michigan?
yes.
Thank you. Now, what drew your attention to that vehicle?
We were sitting stationary facing northbound on Center, and that car was going much faster than the flow of traffic when we initially saw it.
And what does that indicate to you when a car is going faster than the flow of traffic?
When they're going like much faster, like rapidly passing through the vehicle, they're probably going above the speed limit generally.
Do you recall what the speed limit was on that road?
In that area, it's like 35 miles per hour.
And you said you were stationary, correct?
Yes.
How did you respond to seeing that car?
We ended up pulling out, going westbound on Oakland as well, and getting behind the vehicle.
You said we. Can you explain who else was with you?
Officer Vanderwerf was in the car and he was driving it.
Thank you. Do you recall what speed the car was going?
So when Officer Vanderwerf got behind the car and he was pacing it for about a city block, I peeked down at the speedometer and we were going about 50 miles on the calibrated speedometer.
And that was still in a 35-mile-per-hour zone?
Yes,
Was a traffic stop initiated?
yes.
And can you tell me about that stop?
Initiated the traffic stop, got out of the car, made contact with the occupants of the vehicle. Officer Vanderwerf made contact with the driver, was asking him for his information such as his driver's license and whatnot. The driver wasn't being really compliant with providing that information, was saying derogatory things and whatnot. You want me to keep going or?
Okay, no, you can stop there, thank you. Now you said there were multiple occupants in the vehicle?
Yes, there were 3 occupants.
Three, okay, and who did you make contact with?
I ended up making contact with, I can't really recall his name, but I was with the passenger and backseat passenger initially.
Or when you were at this traffic stop, did you observe anything out of the ordinary?
I would say just from my training and experience conducting many traffic stops, the driver's behavior was unusual, especially with the other passengers being extremely compliant of just a basic speeding traffic stop and trying to just get a driver's license and whatnot. It's not typical for normal traffic stops, no underlying things going on.
At any point, was anything located or was anything seen inside the car?
Yes, I saw marijuana during our initial traffic stop and found a firearm.
Okay. And can you explain to me where this marijuana was that you saw?
It was in the glove box of the car.
And why was that marijuana significant to you?
It was significant because none of the occupants of the vehicle were 21 years or older. So minors in possession of marijuana can't legally possess.
Okay. And did you confirm that they were all under the age of 21?
Yes,
Based on this, was a search done of the vehicle?
yes.
And who conducted the search?
I conducted the search of the vehicle.
And other than the marijuana, was anything significant found in the vehicle?
Yes, a firearm
And where was that firearm located?
in the trunk of the vehicle in a black duffel bag.
And when you searched that duffel bag, do you recall hearing anything?
When I started to search the duffel bag, I heard Mr. Hunt say, "Oh, there's nothing but gym clothes in that bag. I've been living out of that bag." And I was like, "Okay." And I continued my search, and then shortly after, found the firearm.
And you said, or I'm going to back up just a little bit here. Did you make contact with Mr. Hunt on the scene?
Yeah, so when he was starting to be a little bit more uncooperative with Officer Vanderwerf, I came to the driver's side of the vehicle so that we could get him out of the vehicle.
So Mr. Hunt was the driver.
Yes, Mr. Hunt was the driver.
Thank you. And do you recall at what point he was identified as Mr. Hunt?
I think, because then I started going and dealing with the passengers, but I think Officer Vanderwerf was able to get his driver's license when we got back to our patrol car.
And would you recognize Mr. Calvin Hunt if you saw him again?
Yes,
And is he present in the courtroom today?
yes.
And could you describe him by something he's wearing?
Or like a black hoodie with some white lettering on it.
At this time, Your Honor, the people ask that the identification of Mr. Hunt be entered into evidence.
Any objection to the witness identifying the defendant for purposes of prelim, Ms. Schroeder?
For purposes of preliminary examination only, no objection.
Thank you. The witnesses have identified the defendant for purposes of prelim. Mrs. Zell, you may proceed.
Thank you, Your Honor. Going back to that handgun, can you describe that handgun you found?
It's like a black and tan semi-automatic handgun. Have a magazine. Well, at the time as well.
Thank you. And was there a serial number on that? Do you recall?
Yes,
And do you recall running that serial number at all?
yes.
Do you know who the owner of that firearm was?
I do not remember the owner. I just remember that it was stolen out of the Reading Township.
Thank you. No further questions, Your Honor.
Cross-examination, Ms. Schroeder.
One moment, Your Honor. Officer Mosby. So you indicated that you were, if I understood, you were stationary, correct, initially?
Yes, ma'am.
All right, and you were not the driver of the vehicle, correct?
No, ma'am.
Okay, and you weren't using any type of radar gun, is that correct?
Nope.
Okay. So you were doing it and you indicated that there was a calibrated speedometer. Do you know when the last time that speedometer was calibrated?
Nope.
Okay. Do you know if it ever actually was calibrated?
When we get our police vehicles, they're certified calibrated. You can check with the city.
But you don't know when that would have been, correct? Okay. And you don't have any type of specialized certification in being able to judge a speed. Would that be fair?
Wouldn't say so.
Okay. And then you indicated that it was like 35 miles an hour. Is it like, was it 35 miles an hour or wasn't it?
It's 35 miles per hour.
And is that based on your knowledge or just something someone's told you?
My knowledge.
And you indicated that you came over to the side of the vehicle where you said, if I understood correctly, you went to the driver's side when you noticed that Officer, was it Vanderwerf? Is that what am I saying his last name correctly? Okay. You noticed that Officer Vanderwerf was having some disagreement with Mr. Hunt from your reason. You went over to that side?
Yeah, he was having some non-compliance issues with Mr. Hunt.
So you didn't stay on the other side with the other gentleman from the vehicle?
I could see them, but no, I did not.
And you indicated that you're the one who ran the firearm for its serial number?
Yes.
Nothing further.
Redirected Mrs. L.
No, Your Honor. Thank you.
All right. May this witness be excused from the people,
You may.
from the defense?
You may.
Right, thank you, sir. You're excused.
Thank you, Your Honor.
And then I think Mr. Austin is in another court.
I believe so, Your Honor.
All right, so we'll get the next witness.
Yes, I'll be right back. Your Honor, if I just may, can step out for just a second.
All right. Any further proofs from the people of Mrs. L?
Yes, Your Honor, the people also call Officer Haven Hyatt to the stand.
Officer Hyatt, you need to stand in front of me and please state your first name and your last name for the record.
Haven Hyatt, Havenhiatt.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, have a seat. As you know, the microphone is for the recorder's recording purposes. It does not amplify your voice, so please project to the back of the room. Mrs. Owen, you're ready.
Thank you, Your Honor. Thank you for being here today, Officer Hyatt. If I could start by just asking, where are you currently employed?
Lansing Police Department,
And how long have you been employed there?
approximately 1 year and some months.
And do you recall working on July 4th of this year?
Yes, ma'am.
Do you recall responding to a traffic stop at Oakland and Holden Street?
Yes, ma'am.
And did you go to that location?
I did.
And what did you observe when you arrived?
A red Cadillac CTS parked on the east side of the street. Mr. Hunt standing out front of my partner's patrol car and Officer Mosby searching the car.
And were you present when this search was completed?
Yes, ma'am.
And what was found in that search?
I observed Officer Mosby searching a black duffel bag. Mr. Hunt told me that there was only dirty clothes in there. He lived out of that bag because he was working at Amazon. And then Officer Mosby advised he located a firearm in that bag. They placed Mr. Hunt under arrest.
When Mr. Hunt was placed under arrest, were his Miranda rights read?
Yes,
And did you speak with Mr. Hunt after that?
I did.
And what did you gain from that conversation?
I asked him if the firearm belonged to him. He said it did. He advised he did not have a CPL and that he found the firearm.
And were you aware that there were other people in the vehicle?
Yes,
Did Mr. Hunt tell you about any of those people?
yes, he stated all property inside the vehicle was his.
No further questions, Your Honor.
Cross-examination, Ms. Schroeder.
One moment, Your Honor. Did you happen to, Officer Hyde, did you happen to observe anything with regard to the running of the firearm, the serial number? Do you recall?
I walked up to Officer Vanderwerf, and at that time I heard Ingham County Dispatch advise over the radio that it was stolen.
Okay, but it was Officer Vanderwerf you saw doing that?
Yeah, he was the one in possession of the firearm.
Thank you. Nothing further.
Any further redirect of Mrs.
No, Your Honor, thank you.
All right. May this witness be excused from the people,
She may.
from the defense?
She may.
You excuse me and thank you for your appearance today. Any further proofs today, Mrs. L?
No, Your Honor, at this time the people rest.
All right. Any proofs today, Ms. Schroeder?
Not at this time, Your Honor. Thank you.
All right. A motion for bind over, Mrs. L.
Thank you, Your Honor. Your Honor, today Mr. Hunt is in front of you charged with concealed carrying a weapon, specifically a firearm, and specifically under the theory that the pistol was concealed on or about his person and or concealed in a vehicle operated or occupied by the defendant. Your Honor, you heard in this case from Officer Mosby and Officer Hyatt. Officer Mosby was able to relay the reason for the stop today for being speeding, relay the reason for the search being marijuana in the car with occupants under the age of 21, giving probable cause for search of the additional vehicle. Upon that search, they did find a firearm located in a black duffel bag in the back of the car. Officer Hyatt did testify today that it was Mr. Hunt who told her after receiving his Miranda warnings that the bag was his, that he had been living out of his car, that the firearm was his, and that no other belongings in the vehicle belonged to anyone else in the car. Your Honor, at this time, we believe we've met a probable cause standard to show that Mr. Hunt did conceal carry a firearm, specifically a pistol, in this vehicle on July 4th in the city of Lansing. We ask that the case be bound over as charged. Thank you.
Thank you. The response, Ms. Schroeder.
Thank you, Your Honor. We did hear, as the prosecutor pointed out, testimony regarding a firearm and a traffic stop. Respectfully, we would find the reason for the traffic stop being that it looked like a vehicle was going faster than traffic, but we don't know anything about any proof regarding how fast that vehicle was actually going. The fact that we were just a stationary vehicle, someone testified wasn't even the driver of the vehicle that they used to pace allegedly my client down the road or up the road, pardon me, and So we don't even have the officer who actually was the driver, who actually was the one doing the pacing, making those observations. We have something from the passenger, Officer Mosby. So, and we don't even know how reliable the what they were using to make that traffic stop was with regard to no specific specialized training being talked about, no specifics with regard to any equipment being used, no specifics with regard to calibration of a police vehicle. So we have him being stopped. The car, because they didn't like the way he was interacting with them, they take him out of the car. And defense, I would acknowledge the fact that there is case law that states that you can take someone out of a car, but at the same time, that's what that boils down to. We didn't hear any testimony as to how they got into the glove box. So we don't even know with regard to, suddenly they're in a glove box and now they're searching based on that. And then we have two officers. We have one officer stating he ran a serial number and the other officer stating, oh, a different officer ran the serial number on that gun. I would ask, where is Officer Vanderwerf? Because he's the person here who's got the best information if we're going to actually do this. So I'd ask the court to deny bind over. I think these are it's just two loose connections here. Thank you.
Thank you. Response of Ms. is up.
Thank you, Your Honor. I believe the testimony today from Officer Mosby did establish that the car that they were following was going well over the 35 mile per hour posted speed limit, and that was from Officer Mosby's direct personal observations. He was able to provide that. As to who ran the gun specifically, I don't think that's very important here, mainly because Mr. Hunt did admit to having the gun to Officer Hyatt. Additionally, as to how the glove box was entered, this was I believe Officer Mosby did testify just to as seeing it in the open. However, I will agree that testimony did not come out. As to the reliability and support and how credible these witnesses are, that is a question I think that should be left to the jury. And at this time, we do still believe we've met that probable cause standard for bind over. Thank you.
Now, the standard for preliminary examination is probable cause being the second lowest standard in criminal law, reasonable suspicion being a lower standard. I believe I've heard witnesses of Officer one. Witness one was Officer Mosby. Witness two was Officer Hyatt. I find that location, venue, and date have been made at a probable cause level. Identification was made by Officer Mosley at a probable cause level. And so all those have been made. And then we go to the elements of the crime. It would appear Officer Mosby testified that the initial traffic stop was for speeding, indicated speeding. And then as he was dealing with one of the backside passenger and a passenger, he did observe at some point in the glove box marijuana, and all were minors in the vehicle, which stems to a minor in possession of marijuana, which is problematic. Both sides had the opportunity to question concerning Mr. Mosby concerning the observation of marijuana was available on cross-examination. But that led to the actual search of the vehicle, probable cause search of the vehicle, which found that in a duffel bag in the trunk where Mr. Hunt or the defendant indicates that was my stuff. That was said during a part of the search. A handgun was found, a pistol, and then later to Officer Hyatt after being arrested and after Miranda indicated the same to Officer Hyatt, that is his gun. They weren't responsible. As a matter of fact, he said nobody but him was responsible for anything in the motor vehicle, according to Officer Hyatt. Was said after Miranda. I believe the elements of the crime have been proven at a probable cause, satisfied at a probable cause level, in that as to count one will be bound over as charged. That Mr. Hunt did on July 4th at West Oakland and Holton in the city of Lansing, Ingham County, carry a dangerous weapon, to it a pistol, concealed or about his or her person, and whether concealed or otherwise, in a vehicle operated or occupied by himself, and that was the Cadillac CTS that he was the driver of. And then the search was done, and found the handgun there that he indicated was his pursuant to the probable cause has been proven. And I will bind over and sign the bind over for the date, for today's date. So the examination was held on today's date, which is 7/24. And is bound over on the charges in the complaint as charged. Is there anything else to come to the court's attention before I sign the bind over documentation? Mrs. L.
Not for the people.
Ms. Schroeder.
Half the defense, thank you.
All right, I'm gonna sign the bind over documentation. Mr. Hunt, your time in district court is done. You're off to circuit court. Well, you'll get your next notice to appear from your attorney, Ms. Schroeder. All right, sir?
Sure.
All right,
And I think it's the paperwork to sign for the transcript.
absolutely. So the paperwork will be made available to you to sign for the transcript, and I'll sign the bind over documentation. And that's all on the record in 2502-009. Thank you, everybody, for your appearance.
All right. I gotta you, and then we'll figure out what we're
I
doing.
don't know if Mr. Austin's on the record or not.
I did see him next door.
Yeah, he said he had a Freeland.
Yeah, he's got quite a bit today, Your Honor. Is there anything I can assist with regard to this matter?
Probably not on Mr. Austin's case, and I think he's on the record, so.
Okay.
Yeah,
Does anyone know where Etheridge is?
I saw him walk in the halls, yeah.
Just wanna talk.
I'll get him then, and we should be able to call this.
all right.
Where we at? Well, I know. So my question.
Feeling we were gonna lose Austin. I had a feeling we were gonna lose Austin. I can't. Yeah. Docket 25-01608. That is People of the State of Michigan versus Mark Delamarter. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Etheridge.
Good morning, Attorney Derek Etheridge on behalf of Mr. Delamarter. I'm from the Office of Public Defender. Mr. Delamarter has not appeared this morning.
Right, this was scheduled for 8:30. It is now 10:30, 10:35. And based on the representations of counsel, I do not see Mark Delamarter in the Zoom courtroom, physical courtroom. And Mr. Etheridge has indicated he's looked for him in the hallway. It would appear that the defendant has failed to appear for the preliminary examination today. Mrs. L, how would you like to proceed?
Your Honor, in this case, the defendant has failed to appear previously, I believe. Yes, on June 20th, there was a failure to appear. We did ask for a bench warrant at that time, and I believe we are going to go ahead and ask for a bench warrant to be issued at this time as well.
Right, I have two failed to appears, once on June 20th and once on July 3rd. but then on the 3rd, we quashed the bench warrant and we reset for July 24th. It would appear the defendants failed to appear based on the representations of counsel. Have you had any contact with Mr. Delamarter, Mr. Etheridge?
Your Honor, I did, like at the PCC, he did appear for the preliminary, but he was like an hour and a half late. He did call and say he was gonna be 45 minutes to an hour late, or called or emailed the court, and I got that message. But since the last court date, I have had no contact with him. My understanding at the last court date that none of the witnesses appeared, and it would likely been dismissed then if he would have appeared. I'm not sure if they're here today or not.
Yes, Your Honor, we do have the witness that is needed for this case, ready to go. He's been here since the case was set at 8:30.
All right, with that understanding and lack of contact with Mr. Delamarter and the prior fail to appear, we'll issue a bench warrant concerning this matter. Any comment on that, Mr. Etheridge?
Oh, yeah, I leave the court's discretion.
All right.
In light of him not appearing like 3 times, it would be obviously appropriate.
All right, so bench warrants issued for non-appearance. Anything else for the record? In 25-016-08, Mrs. L.
Not for the people.
Mr. Etheridge.
No, yeah, thank you.
Thank you. We should be all set on that file. Mrs. L, did you need to let the witness go?
I do, Your Honor, if I could have just a second.
It never got it.
Maybe I have it. Oh,
Officers by the wrong names today.
That's all right. Will happen. What did you want to, I have Hal Kalzinski with Mr. Freeman, and then Mr. Kissy with Mr. Austin. Did you want to call any of those cases?
If I could just have 1 second, I think we can call the Kalchinsky case as long as Mr. Freeman's ready. Unfortunately, I don't have witnesses here for that case today.
All right. And is Mr. Kalchinsky here?
Yes, Judge, he's in the hallway. I'll be right there.
All right. All right, so we're on the record in docket 25-01615. That is people of the state of Michigan versus Corey Kalchinsky. Will the parties please introduce themselves for the record? I might need help on that pronunciation. Ms. Azell.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Freeman.
Yes, Your Honor. Good morning. Stephen A. Freeman, Assistant Public Defender, on behalf of the defendant who stands to my immediate right.
And sir, you are Corey
Donald Kozinski.
Kalzinski?
Yes, sir.
All right, thank you. This is the time set for preliminary examination. Mrs. L, how are we proceeding?
Your Honor, It's my understanding that defense wants to run the exam today. However, the people are unable to proceed. The officers that were subpoenaed for today's court date did not appear. As the court is aware, we've been having some issues with our subpoenas. However, it's not been indicated that's the issue in this case. I'm not sure why the officers are not here. We did get in contact with one officer who said they didn't know they were supposed to be here today. However, I do think that is an issue on our end. We would ask for an adjournment. However, we do understand that defense will likely make a motion in this case.
All right, Mr. Freeman.
Yes, Your Honor, thank you very much. If this court determines that the people have demonstrated a good cause or just cause, on the other hand, if the court does not, then obviously on behalf of my client, I would respectfully move for dismissal without prejudice.
All right, this was set for probable cause conference. We left on for preliminary examination. It would appear the witnesses have failed to appear. So Mr. Kalzinski, usually I'm going to grant, I am going to grant the motion dismissed without prejudice today. But usually we default that it's going to be, this may be reissued, all right? And then the whole thing starts again. You get arraigned, the whole 9 yards. That's your preference today. Mr. Freeman is saying that this is a dismissal without prejudice. Is that correct? All right. That was Mr. Freeman's indication. I'm going to grant the motion based on the public defender's request for grant the motion to dismiss without prejudice. There's not any, it appears that this may be a subpoena issue, but it's certainly not the fault of Mr. Krasinski. So I'm in possession of case number 25-01615. That's the order of acquittal or nollie pros. And I'm going based on the motion, the people are unable to proceed, and the defense has requested a motion to dismiss without prejudice, which is granted. And then the dismissal without prejudice was explained to the defendant. So I will grant the motion dismissed without prejudice. Mr. Calzin, this may be reissued, okay? And then be in contact with the public defender's office concerning this matter. That's up to, that'll take some type of review process, but the case is dismissed without prejudice today. Anything else for the record in 25-01615, Mrs. L?
Not for the people.
Mr. Freeman.
May I inquire of the court and ask that someone from the court staff send an email to our tethered friends out in Mason?
Absolutely. There's a GPS and there's a GPS. And so we will email, you'll have to go back to Mason to have that removed, but we will email the private entity that put that on so they'll see you coming. All right, sir? All right. You should probably, it takes about a few hours to purge this from the system. So we'll give you a copy of this to keep on your person. All right.
Thank you.
All right. Anything else for the record, Mr. Freeman?
No, Your Honor. Thank you.
All right. Thank you. You're all set. You can get a copy of the order from my court officer. In docket 25-01625. That is people of the state of Michigan versus Joey Kissy. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor, filling in for Assistant Prosecutor Jennifer Lawton.
Thank you. And Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin appearing today on behalf of Mr. Cassie. He stands present to my right.
And sir, you are Joey Kissy, is that correct? All right, thank you. This is the time set for a CSC preliminary examination. Ms. Zell, how are we proceeding?
Your Honor, it's my understanding that today there will be a waiver of the preliminary exam.
Is that a fair statement, Mr. Austin?
That is my understanding, Your Honor.
Okay. May I inquire of your client of the waiver of the preliminary examination?
Yes, you may.
All right, Mr. Kissy, you understand that you have a right to preliminary examination today. The preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Jared Austin. He would be present to cross-examine any witnesses, contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to preliminary examination, have this case continue to circuit court where negotiations are continuing between your lawyer and the people of the state of Michigan. Is it your wish today to waive your right to preliminary examination? Okay. Ms. Dizelle, do the people also waive their right to a preliminary examination?
We do, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide the bind over information for the parties to sign. All right, I'm in possession of the bind over documentation on 25-01625, signed by all the parties. I'm going to indicate that the examination was waived on today's date, which is July 24th, 2025. And before I sign the bind over documentation, anything else on the record in the file? This is out from the people.
Your Honor, we would just like to clarify that this is an unconditional waiver. Thank you.
All right. I wrote that one time and they didn't, and they weren't sure what an unconditional waiver meant, but it is, I'm placing it again. We'll see. But right now, this is just a waiver without an offer, and negotiations are to continue. Is that correct?
Correct, Your Honor.
Anything else to come to the court's attention before I sign the bind over documentation, Mr. Austin?
If I may address the bond, Your Honor.
You may.
Your Honor, the bond is currently set in a matter for Mr. Cassie that he cannot afford to post. I certainly understand the seriousness of these allegations are not lost on me, but a few things I would ask the court to take into consideration and consider. One, apart from the allegations in this case, Mr. Cassie does not have or would not have any direct ties to the complaining witness or the family in this case, so I don't think there's going to be any issues by abiding by the no contact order. He would be living with his mother in Eaton Rapids, which is a considerable distance away. It's a separate county away from where I believe the complaining witness and her family resides. He acts as a caretaker for his elderly mother, who I think relies on his assistance to help her with day-to-day living. Um, To the best of my knowledge and belief, Mr. Cassie does not have a history of failing to appear for any court dates. Also, I have not been made aware that while Mr. Cassie has been incarcerated, that there have been any attempts by either him or anyone on his behalf to circumvent the court's orders or the no contact order, or to interfere with the witnesses in this case in any way. I realize that Mr. Cassie does have prior criminal history, some felonies, some misdemeanors. He's certainly never been convicted of or even accused of anything remotely of this nature, which involves a child or a CSC of a child. And I would note, Your Honor, that the last conviction that Mr. Cassie had is nearly 20 years ago. So I would ask the court to take all of that into consideration and grant him some relief, either in the form or the amount of his bond.
Thank you. Mrs. L, response.
Thank you, Your Honor. The people object to any reduction in bond in this case. This is a CSE first and a CSE second, both involving a 6-year-old victim. The defendant did post some CCM images of this victim online. That's how we got this case here today. The CCM is still being investigated by the federal agencies, and they're doing extractions on these electronic devices of his. We are expecting to see some federal charges coming out of that. Additionally, Your Honor, talking about prior criminal history, this defendant does have 2 prior indecent exposure convictions and some domestic violence convictions. Your Honor, with all that in mind, we would ask for the bond to remain the same and for any reduction to be denied. Thank you.
Thank you. Based on the prior criminal history, these are 2 life, well, one's a life, count 1 is a life offense, count 2 is a 15-year. I'm going to deny the modification of bond. This was set by Judge Buchanan on June 4th, 2025. I'm not going to override her initial indication concerning this matter, and I'll deny any bond modification. Anything else for the record? So your time in district court is done. You'll get your next date from Mr. Austin in circuit court, Mr. Kissing. Anything else for the record? 2501625 at Mrs. L.
Not for the people.
Mr. Austin.
No, Your Honor. Thank
All
you.
right, thank you. I'll sign the bind over document. And that's all for the record in the file. Thank you for your appearance today.
No, it's good.
Mr. Austin, you're off to Judge Simmons.
Yes.
Thank you, Judge. Have a good day.
You too.
That's why I'm at with it. And I mean, if
Who knows? Who knows what's gonna
Oh, do we need to bring up Mr. Howe?
yes.
Okay.
Yes.
You let Megan know?
Yes, I did. She
All right.
actually told me not to go anywhere. I better not. leave.
Okay.
So I
She's
believe
a little
that-
sassy, that one.
I believe that may have been her telling me she is bringing up my client.
Oh, okay.
Yay! I'd like to point out that I am no longer the sassiest person in this office.
Listen.
I think it's a strong running for first place there. But as we've gotten to know Megan better, she's
spicy.
she has a little sass to her, a little spiciness. So I'm gonna take a break and just walk around because they'll make my physical therapist happy. Just let me know. Just let me know when you need me, all right?
Absolutely.
All right.
Thank you, Your Honor.
Oh.
It's kind of hard with the chain, yeah.
All right, so we're on the record in docket 22-03340. That is people of the state of Michigan versus Tyrone Howell. Will the parties please introduce themselves to the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Schroeder.
And thank you, Your Honor. Assistant Public Defender Aaron Schroeder, on behalf of Mr. Howell, who is present, stands to my right.
And sir, you are Tyrone Devontae Howell, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination, NAPA 53 violation. Mrs. Zell, how we proceed?
Your Honor, at this time, the necessary witnesses in the people's underlying case for the preliminary exam today did fail to appear. They were subpoenaed for today's date. We have no indication that those subpoenas failed in this case. One of those subpoenas actually did properly get to an officer, however, it was the wrong officer, and we do take responsibility for that. For that, Your Honor, we would ask for a brief adjournment because we do believe we can get the necessary officers here. We do know that defense is not willing to stipulate to that, and we'll be making a motion today. On the PA 53 violations, Your Honor, we did have officers here and ready to move forward. However, it's come to my attention, mainly because I'm the one who did this. There are new charges that are coming through the system arising from one of those PA 53 violations. An additional case is also coming through that is not related to those 53 violations. But we would be willing to dismiss those violations today if the court so chooses.
All right, so you're unable to proceed on the underlying file of 22-03340 today and requesting an adjournment. And then we have in my understanding at prior PCC in December 8th of 2022, we had a fail to appear. Your arraigned, Mr. Howell was arraigned, it looks like in November of 2022. That was the initial arraignment.
I believe that's correct.
And then it was picked up on 2025. That looks like it was arraigned and then applied for court-appointed attorney. All right, Ms. Schroeder, response. I think, first of all, is the response to the request for adjournment.
Thank you, Your Honor. We would be opposed to that. We were here today. We were prepared to, if necessary, to proceed. Mr. Howell is being held in on no bond for this file currently. And this file is from 2022. They don't have the right officers here today. They don't have an alleged victim here today. And it sounds like there might be another case coming. I don't know, but there's always the option that the people can refile if in the future they find a way, they figure something out with regard to their witnesses situation. However, at this time, I'd ask for the case to be dismissed. It obviously would be without prejudice. It can always be refiled. And the fact of the matter is Mr. Howell has been in custody consistently. And that would be our request. And at this time, at the bare minimum, I mean, if the court was going to be willing to give him a PR bond to be able to get out, I'd request that. But other than that, I would ask the court at this time to dismiss.
All right, thank you. My understanding, there's no bond on it. It's been remanded for PCC because of because of the fail to appear December 8th, 2022. Looks like he was rearranged on July 25th, July 10th, 2025. Does that appear? Is that the second arraignment after the fail to appear? And
Yes.
and it was remanded by Judge Buchanan.
I'm sure he was remanded a magistrate probably.
Okay, I have.
I'm trying to send him this year.
Okay. All right. Any response, Mrs. Zell, on any comments made by Ms. Schroeder?
Just briefly, Your Honor, it's not that we couldn't get the officers here specifically. One of the officers was unavailable today. She was unavailable on another case we had today as well. She simply could not find childcare for today and was unable to make it in. The other officer, we did have improperly subpoenaed. We clicked the wrong box in our system, so that was the wrong, that was the improper officer. However, that officer did appear today, even though it was the improper officer. As for the complaining witness in this case not appearing, it was our stance today that if the officers were available and able to move forward, we would be moving forward victimless on that underlying case to proceed on that exam. We do believe that we would be able to get the necessary officers for that bind over here at the next date, simply just because it was a miscommunication on one of those officers on our fault and the other being unavailable today. That is why we are asking for that adjournment, Your Honor.
All right, based on the prior fail to appear, I am going to set bond. I'm going to find good cause to adjourn it. So, Mr. Al, you won't be waiving any rights today. And then I will set the initial bond that was set, so it will not be on remand. So bond would be set at 10,000, 10%. We'll do a good cause adjournment of the preliminary examination, and we will reschedule it for as soon as we can because Mr. Howell is incarcerated, but you're no longer remanded. So you're under the original bond that was set. And let's set it for preliminary examination. So we'll set for preliminary examination for
August 14th.
August 14th at 8:30.
Did you want the GPS?
Yes, if you're able to make bond, we will do a GPS tether. And it'll be with victim notification if possible. So it'll be victim notification if possible. Otherwise, it'll just be zone notification with the last known address of victim, of the alleged victim.
Thank you.
And so we'll continue all the other, so I'll go ahead and check that GPS. But all the other conditions remain the same. No use of drugs or marijuana, no assaultive behavior, no out-of-state travel, no contact with Ashley Beauchamp, no possession of firearm. I think no MJ is no marijuana.
Yes.
And report to pretrial services within 48 hours. All that will be applicable for the original bond that was set by Judge Buchanan.
Yes, sir.
And then and so we will not. So bond is set at 10,000, 10%.
Thank you, Your Honor.
Again. All right. Anything else for the record in 22-03340, Mrs. L?
Not for the people.
Ms. Schroeder.
Not for the defense, thank
All
you.
right. We will also dismiss the PA 53 violations at the request of the prosecutor, with the understanding that those allegations may lead to additional charges. That's all for the record in 22-03340 or the accompanying PA 53 violation. Thank you for your appearance today.
Thank you, Your Honor.
Thank you.
Thank you.
One second.
Hang on.
And the AG's on the
I
file
will
this
connect to
afternoon.
Mr. Jail if I'm not already on there.
Mrs. L.
Yes.
Okay. Mr. Bachman.
Yeah. Aaron Schroeder. I don't, this was my paralegal. She probably sent you the police report. I'll connect to, and then we can talk about that, okay? All right, yep, you're welcome. And then don't forget you got court coming up on, well, next week with Brian Jackson. Yeah, all right.
Thank you, Ms. Schroeder.
Thank you, Your Honor, as always.
All right.
All right, see you later,
We'll
guys.
see you next time.
Bye.
Mhm.
Have a good one.
Yep, you too.
State of Michigan